So next we're going to look at overruling in the Supreme Court. This is quite a common question that can come up and students find it quite difficult. So you need to make sure you pay quite a bit of attention to this. So obviously we know what overruling. So overruling is when a higher court overrules a decision of a lower court, so scraps it and makes a new one. Now bear in mind the Supreme Court is the highest domestic court in this country. Whatever the Supreme Court has to say, everybody takes note of it. So the fact that if a Supreme Court overruled a law, it's important news, right? So like I say, we know what overruling is. Now, in relation to the power of the Supreme Court, there's two things. Number one, you need to be aware that obviously with the Supreme Court, they can overrule any lower court. So if they overruled a law today, then they're scrapping the old law, making a new law, and everyone else lower in the hierarchy to them has to follow. Now, the big conflict is about whether the Supreme Court has the ability to overrule their own decisions. So in other words, change their mind, scrap an old law that they had made originally, and make a new law. And throughout history, really, they've chopped and changed, and I think probably now they've got a pretty good balance between the two. Now, it is a little bit of a history, so again, if the question came up, it might say something like describe the history of the practice statement or describe how the House of Lords and Supreme Court have used the practice statement. Something along them lines. So you have to talk about how the House of Lords developed it and then how the Supreme Court has used it as well. So with the Supreme Court then, obviously the Supreme Court was introduced in October 2009, which replaced the old House of Lords. Now basically what the rules were that whatever power the House of Lords had, the Supreme Court had exactly the same. So that implies that the Supreme Court in 2010 had the right to overrule their own decisions. Just make sure, technically, it's not called the practice statement anymore. Technically, under Supreme Court rules, it's now called the Practice Directions 3 and 4. Right? Just so you're aware. So, a little bit of a history lesson then. If we start off with right back to the beginning, like I said, the key thing is you need to understand that there's got to be a balance. We appreciate that laws get old, they get out of date, and that they need changing. But at the same time, we don't want them changing all the time because that creates inconsistency. So we've got to make sure we have a good balance, right? So, originally, House of Lords had the power to overrule their own decisions. So in other words, change their minds. So if they made a law and realised it were bad, they could change it and make a new one. We then had the case of London Street Tramways. Now again, you can see where they were coming from. Basically, they said, look, we need to be more certain. The law shouldn't chop and change. So the London Street Tramways case basically said, actually, do you know what? We are bound now. So we have to follow our own decisions. Now, between 1898 and 1966, yes, it was certain, but the trouble is there were no development. So then we thought, actually, do you know what? We have an issue. So in 1966, it was the House of Lords who passed the practice statement. So basically said, look, that's not working. Us being bound and us having to follow our own decision is not working because the law is not being developed and we're applying laws that are bad, incorrect, out of date just because we have to follow them. So, the key thing was that the House of Lords were now, in 1966, always remember 1966 because it's the last time England won the World Cup, that they can now change their minds, they can now overrule their decisions, but the key thing is where it appears right to do so. Right? So it's not saying, right, you know what, House of Lords, you've got free reign, you can chop and change your mind whenever you want. It's saying, yes, you have that ability, but try to not use it too much. In other words, try not to take the mick, use it sparingly. In other words, make sure we get a balance between using it all the time, but at the same time we appreciate that at some points we need to do. Now, technically there is slight restrictions on it, but to be fair, you could argue these points for many. Technically, they're only allowed to use it in certain circumstances, right? And those are to adopt a social change, to adopt an economic change, in order to develop the law, or to correct errors. So even though they've got to give a valid reason why they are overruling their own decisions, to be fair, them four are quite vague. Yeah, something like develop the law or correct errors, they could really use for anything. So it's not like it's really strict. However, saying that, we are very lucky in the fact that actually the House of Lords and the now Supreme Court has had the balance pretty correct, right? So they've used it where they thought, do you know what, we really need to, but at the same time they'd be conscious that we don't want it to happen all the time. So bear in mind it was passed in 1966. The first time we ever technically used it was 2 years after, but it was a very minor case. It was a very technical issue to do with documents in a trial. So even though technically that was the first opportunity, really nobody ever kind of talks much about the case of Conway because it wasn't that big a deal. So the first proper case where they really completely changed a decision was in 1972, right? So again, if you think about it logically, that's not too bad. That's 6 years. So again, if you think about it, they're not doing it all the time. They didn't just get the power in 1966 and thought, oh, nice one, we can just keep changing his mind all the time. They didn't do that. They used it sensibly. Now, in relation to the exam, again, why students find this difficult is because of cases, right? So, with this, you do need cases. It's the same structure. So you need your definition, you need kind of DFC structure. But with your cases, they're very, very picky. So what they need to see is they want to see what the case name is, what the case that it was overruled, small amount of facts, and then a reason. So ultimately, you'll only get the marks if that is covered. So case name, what case it overruled, brief facts, and then the reason. So first important case was the case of Harrington. That overruled the case of Addy, and this was to do with the railway company. So previously, it wasn't the railway company's fault if someone got injured on the track. However, the House of Lords decided to overrule that decision. So now, the old law was it wasn't anyone's fault, it was the parents. The new law is that actually it is the railway's responsibility. So completely changing the law by obviously using the practice statement. When we look down at reason then, what was the reason behind it? They basically just said social change. Obviously companies are now a lot more liable for obviously things like negligence and things like that. And therefore that's why they felt that they needed to change it. Right. Now, even though they've got this ability to use the practice statement, again, they have shown balance, and there has been cases whereby they could have used it where actually they decided, you know what, we're going to create certainty, so we're not. So we've looked at this case example before, but the case of Reed Dowling, even though they believed that it was wrong, they still followed it. So again, it just still shows how important certainty is to the Supreme Court. Next example of cases then is the case of Miliangos versus Havana. Now, a lot of people struggle with these cases because it's long case names. You aren't expected to do the full case name. So if you said, in the case of Miliangos, it overruled the case of Havana, then that would be perfectly acceptable. And this was to do with damages. So the previous law then, which was the case of Havana, said that damages could only be awarded in English sterling. The new law, which was in Miliangos, said that actually damages could be given in any currency. Right? Again, Miliangos overruling Havana. Why? What was the reason behind it? The reason behind it was just to do with economic change. We joined the European Union, we were trading a lot more with Europe, and it just felt that only awarding damages in sterling seemed a little bit out of date, and therefore they decided to change their mind. Now, with criminal law, the thing is with criminal law, in a way, we need it to be even more certain than civil, right? And the reason behind that, obviously, is with criminal, there's potentially that people could lose their liberties, they could lose their freedom. So we don't want criminal law to be chopping and changing all the time. Yeah, people then go into prison and out of prison, all this type of stuff. So ultimately, it's very important that with criminal law, there's a little bit more certainty. So they haven't used it as much for criminal law as they have done the civil law. So these cases you'll have done at criminal, so an added advantage, you hopefully know them anyway. Because of the certainty then, the first use of the practice statement with criminal was actually 20 years after it got passed, so in 1986, and the case of Shivpuri that overruled the case of Anderton and Ryan. Now you'll notice here the years, it was slightly controversial this because it was so close to each other. So a lot of the time, if you look at the previous ones, there is a vast amount of years between the old one and the new one. Whereas this one, I think it actually worked out at less than a year. So it was seen as a bit controversial. However, the kind of House of Lords had to stand there and admit, do you know what, we're really sorry, but we're just completely wrong. So in Anderton and Ryan, they said that you couldn't be guilty of attempting the impossible. Shivpuri was the guy who thought he was smuggling drugs, but in fact it was just ground vegetables. Previously, they said you couldn't be guilty of attempting the impossible. They realised that they'd completely misinterpreted the Criminal Attempts Act. They'd completely got it wrong. So the House of Lords had to hold their hands up and say, you know what, we have massively got this wrong. So they overruled their own previous decision, which was less than a year ago, and they basically said, yes, you can be guilty of attempting the impossible, because at the end of the day, you thought you were committing a crime. So again, going back to your reason, the reason was just simply to correct errors. And then again, another case example that we look at in recklessness is R versus R and G. And this was to do with the mental element of recklessness. If you remember, this case was to do with two young boys who were messing about with newspaper and setting it alight. They'd finished messing about, they threw it in a bin thinking that it wasn't alight anymore, set the bin on fire, and then it set a co-op shop, causing £1 million worth of damage. In this case, it was looking at this idea of recklessness. So did they intend the damage? No, they didn't. The question was, could they be guilty because had they been reckless? Now, the old law, the case of Caldwell, said that it was objective recklessness, i.e., would someone else think that they'd been reckless? Now, again, if you apply that test to these two lads, actually someone else would have thought they were reckless, and therefore they would have been guilty. However, they decided to change that test of recklessness to a subjective test. So did they see a risk? So ultimately the boys weren't guilty because they didn't see a risk. And they just said that the old test of objective is unfair, and therefore we'll have a new test of subjective, which obviously is a lot better. Again, reason, just simply to correct errors. They said the objective test was wrong. Most recent case before the House of Lords changed over the Supreme Court was the case of Hoare, which was to do with damages and compensation in historical cases. So previously, in the case of Stubbins, there was a time restriction from when you could claim damages. However, because there has been a lot more like historical, say like sex cases, that time period elapsed, so it meant that any of these victims that were coming forward couldn't actually claim any sort of compensation or anything like that. So now they've actually changed the time limit and made it a lot more flexible to kind of cover situations like that. Right. So just going back to a possible question that can come up on this area, It'll talk about describe the use, describe the historical use of the practice statement. All you need to be clear is you need a definition of obviously what the practice statement is. In your kind of features aspect, I'd then talk about kind of a little bit of background, a little bit of history, and then you do need your cases. And remember, like I said to you, the cases are very strict. So, what was the case name? Who did it overrule? Brief discussion of it, and then the reason at the end.